We are on the record.
All right, good afternoon, everyone. We are on the record in the 53rd Circuit Court for the County of Presqu'île. We are providing public access both in the Presqu'île Probate Circuit Courtroom and also online. I'm appearing by video from the Circuit Courtroom in Sheboygan County. And we are arraigning one Ricardo Wesley Harris in the case of People v. Harris, file 25-93380FH. Counsel, would you please state your appearances beginning with the people?
Jeremiah Buffalo Wargo on behalf of the people.
David Funk, P26715 on behalf of Mr. Harris.
All right, and Mr. Funk is appearing by Zoom video. Mr. Harris is appearing by Zoom video from a separate location, that being the Presqu'île Jail. Let me know if you need a breakout room with him at any time. And Mr. Wargo is appearing from the courtroom in Presqu'île County. Mr. Harris, it is alleged that you are in contempt of court for violating the conditions of your pretrial release or your bond.
Yes.
And the prosecutor has alleged that you were following the complaining witness in this matter with your vehicle and positioned your vehicle alongside hers, swerved side to side, nearly striking hers, and made some gestures, flipping her off basically. And that there's some video about that. And that would violate the conditions of your bond in several respects, to not have contact with her and not engage in abusive or assaultive or threatening behavior. You've got the right to have a hearing on those allegations where the contempt would need to be proven beyond a reasonable doubt. You have the right to Mr. Funk's assistance at the hearing. You have the right to present evidence in your own defense. If you are found to be in contempt, I could jail you for 93 days. I could fine you for $7,500 or both. Also, if I believe you're not complying with the conditions of your bond, I can revoke that bond. Do you understand the rights you have and the penalties involved, Mr. Harris?
Yes.
And Mr. Funk, do you know how he wishes to plead to that allegation of contempt?
Who would plead not guilty, Judge, and demand a hearing.
All right, we'll enter a plea of not guilty and we'll schedule it for a hearing. We are currently scheduled, I think, for a docket call on March 16 at 10:30 in the morning. We'll schedule the bond violation hearing at the same time. And then I can hear from both counsel about whether Mr. Harris ought to be released or not between now and then. Mr. Funk?
Yes, sir. Judge, I have in my possession a copy of the video. I've read it, or I've looked at it rather. So has my client. And the only thing that video shows is my client driving next to the young lady's car and flipping her off. I don't have any swerving, nothing like that. Additionally, I've requested of the prosecution any evidence that they get from Emmett County, because that's where this allegedly happened. And apparently there was a criminal complaint lodged against my client there, although nothing formal from the prosecutor. Mr. Wargo tells me that he's going to contact the prosecutor there in Emmett, but didn't have any time to do that today. So I'm just requesting my client be admitted to bond so he can go back to work.
All right, thank you. Mr. Wargo, the people's position?
The people's position, Your Honor, is that our complaining witness does indicate that the vehicle was swerving toward her. The video appears to show some erratic driving, but it absolutely definitely shows aggressive hand gestures and pulling up alongside the victim's vehicle in a very rapid manner. Your Honor, this is the exact kind of behavior that warrants no bond in this matter. This is our complaining witness. She feels threatened and intimidated in this situation. We would ask that Mr. Harris be held without bond.
All right, well, Mr. Harris is charged in a several count felony information. One of those counts alleges that he did assault this particular complaining witness by strangulation or suffocation and faces up to 10 years in prison for that. And as a condition of his bond, of course, he's not to have any contact with that complaining witness. And it sounds like, there may be some dispute about whether he's swerving or whether it constitutes an assault, but it appears that there is pretty clear evidence that he pulled his vehicle up alongside the victim's moving vehicle and flipped her off. That's a very intimidating kind of contact. And Mr. Harris, that is exactly the kind of contact that you are not allowed to have. This complaining witness is entitled to move about her day without fear of you hassling her like that. Mr. Harris will be held without release until further order of this court. He's remanded to the care and custody of the Presque Isle County Sheriff. I'll see you on March 16th, Mr. Harris.
See you then, Judge. Thank you.
All right. Yep. All right. Good afternoon. We are on the record in the 53rd Circuit Court for the County of Sheboygan now, and providing public access both in the courtroom and also online on our civil docket. And up next, we have the case of Golden v. Johnson, file 24-9093NI. Counsel, you want to state your appearances, please, beginning with plaintiff?
Good afternoon, Your Honor. Sarah Stemke-Keim on behalf of the plaintiff.
Good afternoon, Your Honor. Dustin Hess on behalf of defendant.
All right. And we had a couple motions that then I got a notice that we were removing about witnesses on both sides. And the only motion that I think is still up is a defense motion to adjourn the trial. Is that right, Mr. Hess? Is that the only remaining motion today?
That's correct.
Okay. Anything you want to say in support of that motion?
Actually, we were hoping to approach Your Honor and discuss this with you off the record if we could.
Yeah, maybe what we'll do is let me end the live stream, and then I won't, let's see, for a protective order and to limit evidence. Mr. Horowitz, what do you want to tell me in support of your motion, sir?
Thank you, Your Honor. I'm Paul Horowitz, appearing pro se with my co-defendant and sister, Kimberly Swackhammer. Your Honor, we're here today with discovery motions. The city's own admissions and actions have created a jurisdictional crisis that requires immediate judgment under MCR 2.116 I1. The city is playing a shell game. They call their orders non-binding advice in court to avoid your review, while simultaneously issuing confirmed violations in the field. They are using advice as a shield and enforcement as a sword. Before we even look at the ordinances, we must look at the city's total lack of authority under state law. Under MCL 125-3407, a property use is a nuisance per se only if found to be in violation. And the statute mandates that the court, not the city manager, shall order the nuisance abated. The city admits officers issued self-executing shutdown orders on August 13, 2024, and again on January 13, 2026, in the middle of a stay of discovery. By issuing cease and desist orders with dates certain to stop, the city bypassed the judiciary and performed.
Mr. Horowitz, hang on, can I ask you, you seem to be talking about something other than the motion that's noticed up for today. Your motion that's noticed up for today is to limit the evidence to information that existed and was known at the time of the cease and desist order back in 2024, or what, I'm sorry, August of, was it 24 or 25? It was 24. August of 2024. You seem to be talking about something entirely different.
I am not. I am talking about the limitation of discovery as required by their actions. And the city's brief that they provided to you, as well as their actions post their brief, require that we address the both the content of that discovery as well as the jurisdiction.
See, no, they don't. See, you're doing the same thing you did last time. You came into court and wanted to argue stuff that you had not filed a motion for and noticed it up. And I told you I'm not going to allow that kind of procedure then. I'm not going to allow it today. Mr. Voigt is on notice to respond to your issue about limiting evidence. That's it. You don't get to ask me to do other stuff. You have to file separate motions for that. So confine your remarks to the motion that has been filed and is noticed for today. That's all you get to argue. not this other stuff.
I
Go ahead.
respectfully disagree. And I'll.
Well, you don't get to decide that. So argue the motion you have. If you say anything else, I'm going to define that you have forfeited your argument then. Argue the motion you filed. Go ahead.
Okay, so are we not going to follow MCR 2.116 I1?
Mr. Horowitz has forfeited his argument. He does not want to argue his motion today. Ms. Swackhammer, do you want to argue the motion that's been noticed up today?
No.
Okay, Mr. Voida, your response.
To give you a little bit of background, Judge, this motion was filed as discovery was originally working toward a conclusion. Frankly, all that was left at that point, from our perspective, was to depose the two plaintiffs in this case. And the motion was filed, in my opinion, because they didn't want to answer certain questions at the deposition. Rather than deal with this on an emergency basis, we reached an agreement, the parties reached an agreement to pause discovery until the court could issue an opinion on this issue. And initially there were some motions set for January 12th. This one hadn't been noticed up for that date. And so we independently noticed this up for hearing, knowing that we're going to be heading toward another discovery deadline. As in my time as a civil litigator, I've certainly seen situations where protective orders are issued during the course of discovery, particularly with regard to sensitive medical records or business records, things that would be detrimental to a party if released publicly during the course of discovery. I've never had a motion for a protective order to keep me from asking questions about the claims that are being made by a party, and to say, well, you can't engage in discovery about the timeline of who knew what when, for example. That necessarily requires me to sometimes ask about things that happened after the cease and desist letter was issued. There are a lot of issues in this case, some of which are before the cease and desist letter and some of which are after. And to try to surgically say, well, we don't get to ask these questions, I think is completely not only against the court rules and not only against the spirit of discovery, but I think it's artificial. I mean, we're trying to learn about this case, learn about the claims being made by the plaintiffs so that we can address this case either in a trial or in a summary disposition motion. And certainly we've addressed this in our brief. As far as the Chenery Doctrine, that's a case involving the Securities and Exchange Commission making a decision. We issue a cease and desist letter.
Yeah, and that's more like an appeal.
Yes.
So, and this is not the appeal case. This is they're suing your clients.
Correct.
For violating their rights.
Correct.
So in an administrative appeal, of course, in reviewing that administrative decision, I look at the record that the decision was made on.
Of course.
But this isn't that.
No, it's not that at all. And, frankly, I don't think I have to go much further at this point, except to say, Judge, this isn't the first time we've been here on
Precisely that question. Yes.
And I know that we've asked for sanctions before. I haven't pounded the table and raised too much of a stink over that. But how many times are we going to have to come here to argue the same issue while we're trying to resolve this case? And at some point it becomes frivolous. And I think we're nearing that point. Maybe we're at that point.
Thank you, Mr. Voida. Mr. Horowitz, I'll give you a rebuttal opportunity to argue the motion that was filed. Go ahead.
Thank you, Your Honor. Mr. Voida is claiming that this is a typical civil litigation case. And he is correct that the Reed Dairy that they cite is between two private parties. However, this isn't a case with two private parties. This is a case where the government has issued an order that deprives a citizen of guaranteed property rights that they had no authority to issue whatsoever. So the fact of the matter is that he is trying to say that this is a typical civil litigation case, but the question in this particular situation is whether or not they had the ability to issue a cease and desist order, which they now claim was merely advisory in their claim, and that it's not bound by administrative law. Once they took the action to deprive us of a property right through a cease and desist order, that was an abatement that is restricted to the court's jurisdiction, they reached a final determination because the ordinance in which they are the rights that they are given to them by the judiciary through the MZEA. 125-3407 clearly says that an abatement order is the right of the court only, not the right of the city, not the right of the city manager, and certainly a letter that says, consider this a cease and desist order on a date certain is in fact an abatement order by every definition. Now, Mr. Voida could claim that it is advisory. However, Michigan law says that the letter is judged on its effect on the property rights, and the property rights of a citizen have been deprived by the order that was done by the city. Now, after Mr. Voida ordered or made that response in the brief, 8 days later, the city, and we attached this in our reply brief, 8 days later, the city issued another cease and desist order, and this time said that the violation is confirmed. A violation that is confirmed has to be reached with a determination. Mr. Voida is asking for discovery into something that his own clients say is confirmed. I don't understand why they need to have discovery to address an item that is confirmed.
All right, thank you. Well, in this case, the plaintiffs have filed a motion for protective order and to limit evidence. Plaintiffs continue to insist that the city cannot present any evidence to support the cease and desist letter that pertains to information they learned after the letter was issued, and they want to prevent discovery into anything that occurred after the letter. Defendants respond that the letter wasn't an administrative action and that they're entitled to discovery and evidence of whether the non-conforming use was abandoned. Defendants also want sanctions, believing this plaintiff's motion to be frivolous. I'm going to deny the motion for protective order and to limit evidence. As I have previously stated and make again clear today, the defendants are not limited in the discovery and presentation of evidence to what they knew on the date of the cease and desist letter. That letter advises the plaintiffs that the city believes there's a use on the plaintiff's property that violates the zoning ordinance. The plaintiffs have now sued, arguing that they have a valid prior non-conforming use that prevents any enforcement of the zoning ordinance as to them. They may prevail factually and legally on that. I have no idea how that's going to shake out. But the defendants are entitled to defend against that claim with all available discovery tools and all available evidence, including that the prior non-conforming use either wasn't some valid prior non-conforming use or that it has been abandoned if it ever was one. So the plaintiffs continue to want to freeze in time this moment that the cease and desist letter was entered. And I've said before, I disagree with that approach. I still disagree with that approach. I'm making it crystal clear the case is not limited to looking at the frozen in time piece of amber of the August 2024 cease and desist letter. I've made it clear and clear again. At this time, I am not granting sanctions, but I do want the plaintiffs to know if they press this argument again, I will impose attorney fees as presenting a frivolous argument that I've ruled against time and time again. Mr. Voida, can you submit an order?
I will, Your Honor. Thank you.
All right, thank you. All right, and now we're going to add a live stream.